Hey guys, today we're going to talk about the probate statement. In an earlier video, I talked about the originating summons, which is the initial document that starts the probate process in Singapore. Today I'm going to talk about the statement, which is another document that is filed together with the originating summons. Now, Practice Direction 62 of the Family Justice Court's Practice Directions is the relevant provision dealing with the statement. And in fact, you can find a sample of the statement in Form 51 of Appendix A to the Practice Directions. It sets out information relating to the deceased and the executor. Now, in respect of the deceased, in Section A of the statement, that will include the name of the deceased, his ID number, his address, his date of birth, the place of death, his domicile. Domicile essentially means where he calls home, and his gender. Now, for the section which states the place of death, it is very important for the lawyer, or if you are doing probate yourself, some people like a challenge and they try to do probate themselves by filing the documents in the court. It is very important that under the section place of death, you copy exactly the place of death that is stated in the death certificate. If the death certificate states Singapore Changi Hospital Private Limited, you copy and state exactly the same name. Otherwise, the statement will be rejected. It has to be exactly as the death certificate. Now, Part B of the statement contains details of the executor or the executors, if they are joint executors, and these would include their names, their ID numbers, and the address. Part C of the statement contains general details including a confirmation by the applicant, who is the executor, that the assets of the deceased do not exceed 3 million Singapore dollars. If the assets of the deceased exceeds 3 million, then the filing fees are higher, and if the assets exceed 5 million, then the probate has to be taken out in the High Court. Another confirmation that the applicant is required to give in Section C of the statement is that the will that was uploaded, the paper copy that was uploaded and filed on the e-litigation, is the same as the certified true copy that was brought to the inspection, the last will of the deceased. The applicant will also have to confirm that he's the sole executor named in the will, or in the case of joint executors, that they are joint executors. The next matter that the applicant has to confirm is that the application for probate is made within 6 months of the death of the deceased. If the application for probate is made more than 6 months after the death of the deceased, you have to give a short explanation why it wasn't filed within the 6-month period. And usually the most common explanation is, I wasn't aware of it. Before filing the statement, it is important to check and double check the particulars in the statement against the actual documents, such as the actual NRICs of the deceased and the executor, as well as the death certificate, because Rule 2082 of the Family Justice Rules provides that the statement, which is filed together with the originating summons for the grant of probate, must be verified by an affidavit of the applicant. The applicant, who is the executor, has to swear or affirm an affidavit, a sworn statement, before a commissioner for oaths, confirming that all the details in the statement is true and correct and are not misleading in any respect. But sometimes human errors do occur, and there may be errors in the statement. For example, errors in the address, the gender, the date of death, the place of death, whatever. If the statement needs to be amended before the grant of probate has been obtained, then a party may do so without the permission of the court, simply by amending the information in the electronic form of the statement. And if you want to amend the statement before the grant of probate is obtained, you have to attach an affidavit stating the reasons for the amendment, and this has to be filed together with the amended statement. So usually, most people go to a law firm to do their probate, for whoever died, and if there is an error in the statement, it's usually because the lawyer, the secretary, the paralegal made an error. So usually it's the lawyer, secretary, or paralegal who keyed in the error, the human error, who has to affirm or swear the affidavit stating the reasons for the error. If it is necessary to amend information in the statement after the grant of probate is obtained by a court, then it is very troublesome and tedious because you have to take out an application by way of summons. Summons is simply an application. You have to take out an application by way of summons. You have to exhibit the draft amended statement in PDF format, and then there has to be a supporting affidavit giving reasons for the amendment. And this has to be attached to the summons.